Uluku, Taina Rose Muyunga, Kaluna Mulunga, Inunik Uyunga, Perusasi Malungalu, Echaluni Nunavumi. Hello, my name is Tina Rose. I'm a Caucasian, born and raised in Iqaluit, Nunavut. I would like to thank Joey, Zoe, and Erica for organizing the Read the TRC project. As the original peoples who had occupied the lands and territories for thousands of years throughout the region that became Canada, Aboriginal peoples have unique legal and constitutional rights. These rights arose from their initial occupation and ownership of the land, and were affirmed in the Royal Proclamation of 1763, which also decreed that the Crown had a special duty to deal fairly with and protect Aboriginal peoples and their lands. Subsequently, the Dominion of Canada assumed this fiduciary obligation under Section 91(24) of the Constitution Act 1867, which gave Parliament legislative authority over Indians and lands reserved for Indians. Section 35 of the Constitution Act 1982 also recognized and affirmed existing Aboriginal and treaty rights. In several key decisions, Canadian courts have said that the federal government must always uphold the honor of the Crown in its dealings with Aboriginal peoples. In R. v. Sparrow, 1990, the Supreme Court ruled that the government has the responsibility to act in a fiduciary capacity with respect to Aboriginal peoples. The relationship between the government and Aboriginals is trust-like rather than adversarial. The honor of the Crown is at stake in dealings with Aboriginal peoples. In Haida Nation versus British Columbia, Minister of Forests, 2004, the Supreme Court ruled that, in all its dealings with Aboriginal peoples, from the assertion of sovereignty to the resolution of claims and the implementation of treaties, the Crown must act honorably, and that the honor of the Crown is not a mere incantation, but rather a core precept that finds its application in concrete practices. In other words, the honor of the Crown is not merely an abstract principle, but one that must be applied with diligence. In Manitoba Métis Nation Inc. versus Canada Attorney General, 2013, the Métis Nation argued that when the Métis peoples negotiated an agreement with the federal government that would enable Manitoba to enter Confederation, they trusted Canada to act in their best interests and to treat them fairly. The Supreme Court said that in 1870, the broad purpose of Section 31 of the Manitoba Act was to reconcile the Métis community with the sovereignty of the Crown and to permit the creation of the province of Manitoba. This reconciliation was to be accomplished by a more concrete measure, the prompt and equitable transfer of the allotted public lands to the Métis children, paragraph 98. Ruling in favor of the Manitoba Métis Nation, the court observed that their submissions went beyond the argument that the honor of the Crown gave rise to a fiduciary duty, raising the broader issue of whether the government's conduct generally comported with the honor of the Crown, paragraph 87. The court found that although Section 31 promised that land grants to Métis peoples would be implemented in the most effectual and equitable manner, this did not happen. Instead, the implementation was ineffectual and inequitable. This was not a matter of occasional negligence, but of repeated mistakes and inaction that persisted for more than a decade. A government sincerely intent on fulfilling the duty that its honor demanded could and should have done better. Paragraph 128. For treaty peoples or First Nations, The unilateral imposition of the Indian Act, including the residential school system, represents a fundamental breach of the Crown's treaty obligations and fiduciary duty to deal with them honorably in both principle and practice. The Crown's position as a fiduciary with regard to Aboriginal peoples is clearly a complicated and potentially conflicting area of legal obligation. As a fiduciary, the Crown, through the Government of Canada, has a legal obligation to act in the best interests of Aboriginal people to whom it owes a fiduciary obligation. This is the same case for the Bureau of Indian Affairs in the United States, which is commonly referred to as a trustee. As a trustee, the Bureau of Indian Affairs has a similar obligation to act in the best interests of Native Americans and to ensure that other government departments do not act in a manner that contravenes tribal rights and interests or the government's lawful obligations. In the United States, the solicitor's opinions issued from time to time by the Department of the Interior, which has authority over the Bureau of Indian Affairs, are used to give direction to government generally as well as to explain and justify government action. In Canada, it must be recognized that the Federal Department of Justice has two important and potentially conflicting roles when it comes to Aboriginal peoples. 1. The Department of Justice Canada provides legal opinions to the Department of Aboriginal Affairs and Northern Development Canada, ANSI, to guide the department in its policy development, legislative initiatives, and actions. Those opinions and the actions based on them invariably affect Aboriginal governments and the lives of Aboriginal people significantly. Often, those opinions are about the scope and extent of Aboriginal and treaty rights, and often they form the basis upon which federal Aboriginal policy is developed and enacted. Justice Canada also acts as the legal advocate for ANSI and the government in legal disputes between the government and Aboriginal people. In that capacity, it takes instruction from senior officials within the Department of Aboriginal Affairs when the department is implicated in legal actions concerning its responsibilities. It gives advice about the conduct of litigation, the legal position to be advanced, the implementation of legal strategy, and the decision whether to appeal a particular court ruling. Upholding the honor of the Crown and disputing a legal challenge to an official's or department's action or decision can sometimes give rise to conflicting legal obligations. In the Commission's view, those legal opinions should be available as of right and upon request to Aboriginal peoples for whom the Crown is a fiduciary. Canadian governments and their law departments have a responsibility to discontinue acting as though they are in an adversarial relationship with Aboriginal peoples and to start acting as true fiduciaries. Canada's Department of Justice must be more transparent and accountable to Aboriginal peoples. This includes sharing their legal opinions on Aboriginal rights. As noted above, there is precedent for making this change. Not only has the United States Department of the Interior's Office of the Solicitor made public its legal opinions on a range of issues affecting Native Americans, but also these are now widely available online.